Hello, this is Jonathon Daily, and this is the Daily Law Podcast. Hi, guys.
This is pretty much been explained.
Jonathon Daily. For those joining us, this is our first episode. I've done podcasts in the past, but this is the first episode for our Daily Law Podcast. The purpose of this podcast is a couplefold. One, to talk about daily law, our services, and cases that are going on, and give some general helpful legal advice, fun facts, etc. The other point of this is to talk about what's going on in our current news and politics. So that's more of a hobby, fun thing that I like to talk about and do on the side. When we get to that portion of the show, obviously I will let you know. So if you do not like my views and you just can't listen and you're one of those people who is going to cry about what I say, then you may listen somewhere else. But this is America still, and we still are free. Sort of. So I'm going to do what I think's best and do something I love and hopefully educate a few people in the process. And if you enjoy the show, whether it's the legal portion or the political news section of the show, then just give us a like, follow, subscribe on all of our pages, and help spread the word. So let's get into this. I would like to lead my show with a prayer because I do have strong faith, and I think it's important that we do show our faith in everything that we do, our work, at home, everywhere. If you are a devout Christian, you do believe that Christ is Lord, then you shouldn't shy away from that fact. So pray with me. Lord, please help this show to reach people in a positive way. Help me to educate people. Help me to teach people if they're willing to learn, and help me to learn. More than anything, help me to gain something from this and to better my craft, better educate myself, and to overall just have fun and bless this show and bless this endeavor that we are embarking on here. In Jesus' name I pray. Amen. All right, let's get into it. So first, I need a little sipski. I'm into Monsters right now, sugar-free. Obviously not a paid advertisement, I wish. Shout out to Monster. But yeah, the sugar-free, I think, is the way to go for energy drinks. Beside the point, cases and legal fun facts. So a couple of cases I have going on right now. One of my bigger, more heavily litigated case is it's regarding real property. I've got a client, without getting into the details for confidentiality purposes, Okeechobee County. My client is the uncle and aunt of their nephew. The nephew is suing my clients because of alleged breach of verbal contract. We, on the other hand, are countersuing for our partition of real property. So essentially what's going on is there's a piece of property. My clients were added to the deed because they were helping make payments, essentially helping maintain the property. The nephew inherited this property, or was deeded this property before the lady who was unrelated to him passed, but essentially it was their goal. They're saying that he would be inheriting the property, but he was young, naive, and not able to manage it or afford it, the mortgage payments on it. So my client stepped in to help. However, there was no real agreement as to what was going on. Things were going well between the parties, so they didn't, of course, put anything in writing, so they were added to the deed. And of course, they threw a new roof on. They've been helping make payments. They've been doing other financial assistance and other actual work at the property to improve the property. And then, of course, there was a falling out. Now, one party is saying, oh, you guys were just lending me money to help me pay for this place, and I was just you were going to deed the property back to me when I paid off the loan. Okay, well, the only problem with that is this little thing called the Statute of Frauds in Florida. The Statute of Frauds is literally designed for this exact scenario, to prevent this, because if there is an agreement, it should be in writing. If there isn't any agreement regarding an interest in real property, it should be in a writing. Therefore, it should be in the deed. If it's not in the deed, and in this case, in the deed is a simple quitclaim deed in which it says that it is a gift. So that's the agreement. Obviously, it doesn't really make sense for them to just hand over the property, but it was a gift. They probably should have put the actual reason that they were partnering on the property. And it's common for quitclaim deeds to say gift to avoid, not necessarily to avoid, but it makes it less likely that you're going to owe the maximum or the actual amount for documentary stamps, or essentially taxes. If they purchased the property from him, if they had given, let's say, $200,000, $300,000 of consideration for this property, property, then you would have to pay taxes based on that $200,000 or $300,000 of consideration. So if you put gift, then basically you're trying to prevent those taxes from becoming due. So anyways, long story short, statute of frauds is a great defense to this lawsuit because if there was an agreement, it should have been put in writing. Now, they're of course trying to argue a couple of things, that the actual agreement was regarding the money, not the interest in real property. So therefore, the statute of frauds does not apply because the agreement was regarding a loan, not the interest in real property. My answer to that then is, why is there a deed? Why would they have deeded the property then? Why didn't they just sign an IOU? Which brings me to my next point, and this is more of a legal fun fact for those out there to learn a little bit about mortgages and notes. So whenever you buy property, there's what everyone knows, everyone's heard of a mortgage, right? What is a mortgage? In Florida and most states, a mortgage is just a lien. The mortgage is a lien that attaches the debt to the property. Therefore, it's a lien on the property. So if you don't pay your mortgage payment, the bank or whoever gave you the mortgage can come in and foreclose and say, this is a mortgage that attaches this money we gave you to this property. You stopped paying what you owe us, so therefore we're going to foreclose and this property is going to become ours, or we're going to sell it so that somebody has to pay this money off. Now, the note is the IOU. So you sign what's called a promissory note. The note is just an IOU saying, I, Jonathon Daily, or I, whoever you are, borrowed money from the bank, whoever the mortgagee is in the case. I borrowed money and I promised to pay it back. A lot of times, if it's a married couple or more than one person buying a property, it may just be one person that's on the actual note. This could be because of credit reasons. Sometimes it makes more sense. Often for self-employed people, it'll make sense to keep the self-employed person off because banks hate self-employed people. For someone that has really poor credit, they'll keep them off of the note, but they'll still be on the mortgage. Or you can be on the title, of course. So just because you're on the title or on the mortgage doesn't mean that you'll be on the note. The person who actually signs the note is the one who is legally obligated to pay, and if they don't, their credit will be shot, and you can be sued in your personal capacity. Now, you're on the mortgage, so the mortgage attaches that debt to the land. So if you're on title, just because you didn't sign the note, they're still going to foreclose. So don't get any bright ideas there. But anyways, I digress. The only other thing I want to mention about this case is what's called promissory estoppel. Promissory estoppel can be used as an affirmative defense, is really what it's supposed to be used as, but promissory estoppel is also used as actual cause of action sometimes. I don't remember the exact factors off the top of my head, but I know I've done a video on it, so go find that. But essentially, promissory estoppel would be something that we could use in this case as an affirmative defense if the statute of frauds didn't apply, to say, okay, well, if the agreement was just to lend money, then why would we're going to argue, okay, if we lose the statute of frauds argument, we're going to make the argument that they're fine. If you're going to say there's a verbal agreement, sure, we're going to say what the verbal agreement actually was. It was a partnership, right? And, that wasn't in writing. Why didn't you put it in writing? Promissory estoppel says, well, look at the actions. Look at the actions of the parties. If the agreement was just lending money and just helping with the mortgage payments, then why would they go out of their way and put a roof and essentially spend more money than what they lent, what the alleged agreement was to as far as lending the money? Why would they do that? Why would they spend even more money? That makes no financial sense unless there was this verbal agreement over here to be partners on this property, right? So promissory estoppel is a way, an affirmative defense to get around the statute of frauds in this case, because you can show that, okay, yeah, you don't have an enforceable written contract, but there was a promise and one party relied on that promise to their detriment, and they have actions to show that they relied on it to their detriment. Oftentimes it's used if a party had a job or they thought they had a job, but they didn't get it in writing, so they had a job offer, right? They didn't officially accept it, so there's no binding legal contract, but that party went ahead and moved and spent a bunch of money on moving, got a new house, got a new rent, whatever it is, and then they find out that they didn't actually get a job. They don't have a written contract, and the employer says, well, no written contract, so there's no job. That's where promissory estoppel could come in and potentially save them, because, okay, maybe there wasn't an actual written enforceable contract, but there was some sort of promise, and we can show evidence of that promise based on this party's detrimental reliance on the verbal agreement or verbal promise. Why would they do it if there wasn't sufficient evidence to show that it was reasonable of them to rely on the representations of one party in their verbal agreement or verbal promise?